Inter-American Development Bank, and Alejandro Radzyminski from Skadden Arps will lecture about finance services for Latin American companies and governments. Welcome, and thank you so much for being here.
Well, thank you all for staying. I know it's pretty late, it's a Friday, and the happy hour music going on, I guess you must be thinking more than before about leaving and starting your weekend. But I really appreciate your staying, and I appreciate very much the generous invitation of our organizers, and it's a pleasure to be here. And I am going to talk about multilateral financing. As Carlos said, I'm an attorney with the IDB, with the Inter-American Development Bank. I work on a sovereign guaranteed operations division of the legal department. And I'm going to try and talk about legal risks and opportunities of doing business in Latin America through the eyes of the IDB and also through a general introduction to IDB operations and what multilaterals in general do and IDB in particular. So I'm going to try to do this. Yes. So I'm going to talk about multilaterals. I'm going to talk about the types of operations, lending operations that the IDB engages in and is active in. I'm going to talk about the particularities of multilateral lending and specific financing products and a little bit about how each of these products handles and addresses certain of the risks involved in cross-border transactions involving different legal systems. And then a little bit about project financing in particular and bank project financing, IDB project financing. And then final note on what I see are the opportunities and trends with respect to multilateral lending. So first question is, what are multilaterals? So you may have heard a lot about multilateral financing and the IFIs, like international financial institutions, but it may or may not be clear to you what they are, the legal nature. They are public international law organizations, usually created by international convention or treaty, and with which treaty is usually ratified by member countries. So, and they have a status of an international public law entity. Examples of multilaterals active in Latin America are the Inter-American Development Bank, which is one of the most active lending institutions in Latin America, if not the most active. The World Bank, which does primarily public sector or sovereign guarantee projects. The International Finance Corporation, which is the private sector arm of the World Bank. It's a separate organization that lends to the private sector on commercial terms without sovereign guarantees. The International Monetary Fund, which provides specifically budget support, doesn't do projects or project financing. There are regional institutions based outside of the United States. There's the CAF, the Corporación Andina de Fomento. There's the Central American Bank for Economic Integration. Caribbean Development Bank. There are a number of other. There's the European Investment Bank, which is a European multilateral organization that lends to projects around the world, including in Latin America. So there are a number of players in this particular field of financing. And the IDB, in particular, is the oldest and the largest regional development bank. And I'm going to talk a little bit about the IDB so that it illustrates multilaterals in general. The IDB, so I was saying, is the oldest and the largest regional development bank. It's going to celebrate its 50th anniversary next year, and it's been historically active mostly in the public sector in sovereign guaranteed operations, lending to sovereign governments, national federal governments, and to sub-sovereign governments and public entities backed by a sovereign guarantees. That has been the traditional historic role of the IDB. And it has somewhat recently, over 10 years ago now, started lending to private sector companies through its private sector division within the IDB legal entity, and to small and medium-sized enterprises through its affiliate entity, Inter-American Investment Corporation, that does only small and medium-sized enterprise financing. And the IDB does only debt financing. It doesn't take equity interest. It doesn't become a shareholder in its projects, the projects it finances, as a general rule. The IIC does. And the Multilateral Investment Fund, which is also related as an affiliate, is a related entity to the IDB, within the IDB group, does take equity in its investments too, does equity financing, but the IDB does debt financing only. So from a legal standpoint, in our legal department, we look at IDB operations as sovereign guaranteed, as I was explaining, and non-sovereign guaranteed. And what's the principal difference, in my view, between these two types of operations? In one operation, the IDB as a creditor has the full faith and credit of the sovereign member country backing the loan repayment obligations. Whereas in our private sector and public sector non-sovereign guaranteed operations, we don't. So we may have, and we usually do have, a number of additional risks that are not covered or protected or insured against with a guarantee from the federal government or the national government. And these non-sovereign guaranteed operations are usually undertaken on a commercial basis, much like the IFC operations, for example. But the IFC is active around the world, and the IDB in Latin America only. But it takes the terms of private sector type contracts, private sector type protections, and guarantees to the lender. The main differential, well, just to give you a sense of the differential of the multilateral, what's so special or different about multilateral lending, multilateral financing? There are several aspects of it. First and foremost, there's a development mandate. The main reason of the existence of these multilateral organizations is to promote and foster the development in these countries. So that's the guiding principle to all the lending operations. So that's a guiding principle to the creation of specific lending instruments, which has evolved significantly in the last few years. And it's the guiding principle in the day-to-day engagement with our borrower governments, which are also member countries, are also shareholders. And that really is like the primary differential, in my opinion. And then especially for private sector, but if you think about public sector financing, you may think that as well. Multilateral financing has a catalytic effect on the markets. The IDB and other multilateral lenders will lend money in circumstances into borrowers or in industries where other lenders may not necessarily go without the enhancement or the value added that the value that the bank adds and that the multilateral institution adds. In frontier industries or sectors, the bank will take this leading role and bring other financial institutions with it in AB-type loans, transactions, whereas the bank lends as the lender of record in these operations, and other financial institutions participate in the loan. They essentially buy an interest in the loan and a right to be repaid, and they contribute to the principal being disbursed to the borrower. Another characteristic of multilateral lending is, and that's a big one, tax immunity. By creation, it has, under international public law and it recognized in the legal systems of the member countries, it has, all the multilaterals, as far as I know, have tax immunity. So it also adds to the catalytic role where banks might not be otherwise willing to lend, private sector banks, private institutions, and private financiers, if not necessarily banks. The IDB will, and because it's tax-free and the participants of its loan will benefit from this immunity, tax immunity, it will make the investment more, the debt financing more attractive to lenders. And finally, it's a extremely important aspect of multilateral financing, the preferred creditor status. This actually, especially for public sector or non-sovereign guaranteed operations, basically ensures or protects the bank or the multilateral financing institution against the foreign exchange convertibility risk and foreign exchange transferability risk. This is a de facto preference that multilaterals get, and it's been widely and very commonly, with no exception, recognized during financial crises and moratoria from Argentina, Russia, I think earlier on Brazil as well, that multilateral financing institutions are granted from their member countries that ensure that in the case there is a general moratorium, a general restriction on transfer of foreign currency out of the member country, the borrower country, the financial institution, the multilateral lender will nevertheless be able to recover, to have a preferred status and a preference over the transfer of these hard currency, these dollars out of the country. So, and that is a great benefit for the private sector banks that do these deals and lend along with the IDB and the other multilateral lenders. So it's a great advantage and a security, and it's a way they mitigate this currency convertibility and transferability risk by doing a transaction with the IDB. The risk doesn't really exist. And another aspect that is not, would be associated with the development mandate, a specific aspect of bank IDB operations is the strong concern or the strong attention, the intent attention to environmental and social aspects of the projects it finances and the procurement aspects of the projects it finances. So this, perhaps some borrowers may think delays the approval process or brings, I don't know, certain administrative hurdles or is a time-consuming process. From a developmental perspective, this is very beneficial to the countries because it really looks into the sustainability of development in general, and is environmental and social and government procuring sustainability in particular. So the bank, I can talk more about the bank procurement policies if you're interested. They apply in general to public sector projects, not to private sector projects. Private sector companies, borrowers, are usually allowed under an exception to bank policies to adopt their own, to follow their own commercial practices. But for all public sector projects, the IDB procurement rules apply. So specifically about the financing products or financial products offered by the IDB. As I said, the IDB in the last few years has launched a number of investments, a number of financial products that now provide much more flexibility to public sector borrowers, to governments that have specific needs for funds that were not before perhaps met by the products offered by the IDB. So we have these investment loans that can range. Investment loans are loans for a specific project, and not in the sense of a project financing, but a project. It could be the revamping of to cite a very specific concrete example, the revamping of the solid waste management in an urban area in Chile, which was a project I was involved in earlier this year. It could be, for example, a line of credit, what they call a global credit program, whereby you lend to a central bank, a country's central bank, and the central bank creates a credit line for the country's financial institutions to promote, for example, small and medium-sized enterprises in the country. So it has a measured development impact that will be addressed in the project documents, and it has a very different nature from revamping of a solid waste management facility sector in a country. So, there are guarantees. I'm skipping through the policy-based loans. There are loans that are granted not for a specific project in a specific sector, but more broadly for a country to reform its policies. And this can be in any industry, in any particular sector. So the bank staff and the bank experts will work with the local governments to help them reform their political system, their policies on a specific sector. And what types of risks does the bank have in this case? Because usually this type of project is backed by a sovereign guarantee, the only risk would be the risk of non-payment, the repayment of credit risk, which we consider to be extremely low because the project is backed, or the payment obligations are backed by a sovereign with full faith and credit of the sovereign. So there's no particular need in these types of projects, investment loans, policy-based loans, or emergency loans, to enter into a great level of detail such as financial covenants and create, take collateral, create offshore lock boxes or mechanisms like this. For these public sector operations that are guaranteed, the documentation is more straightforward and more standardized. On the private sector side, though, and I'm listing some guarantees. The bank offers also guarantees. They're not used as often as the loans, but credit guarantees and political risk guarantees to cover the political risk that previous speakers have mentioned: convertibility risk, expropriation risk, and risks really arising out of acts and actions of country governments, host country governments. And technical operations and project preparation funding can be granted in a reimbursable, non-reimbursable basis. They can be really grants, donations with obligations, grants, or essentially refundable obligations. And they can be obtained by any company that approaches the bank and wants to assess the feasibility of a project or wants to prepare a project for future funding. And on the private sector side, we have what we call the AB loans that I mentioned. There are these loans that are formally undertaken or granted by the Inter-American Development Bank, but participations of which are sold to other, usually private sector financing institutions that take an interest or participation in the loan. So we call the A loan is the IDB loan. The B loan is the part of the loan, is the loan that is going to be participated out to the private sector. And these are used for corporate financing or for project financing, which I'm going to talk a little bit about in a minute. We have certain eligibility criteria that is listed out in detail on the bank's website, but their eligibility criteria involve size of the project, percentage of total project costs that can be financed, and types of entities that could be borrowers. And usually private sector entities, and now more and more sub-sovereign entities and publicly owned or controlled entities as well, without the sovereign guaranteed. Similar to as in the public sector, on the private side or non-sovereign guaranteed, to use the IDB expression, we have so many terms that are very specific to the IDB. I'm sparing you from all the acronyms, but on the non-sovereign guaranteed side, we have these political risk guarantees as well that protect the investors and the creditors from the risk of a breach of a contract and these foreign exchange risks that are not protected by the general preferred creditor status as in the public sector. And partial credit guarantees that are really payment guarantees. Well, to talk specifically about project financing. Project financing is, just to give you a concept, is usually off-balance sheet financing, the financing granted to a special purpose vehicle or a specific project company for the development of a specific project, and that is expected to be repaid with no recourse to sponsors and to sponsors, or with limited recourse, meaning you're going to have to get paid by the project company, and the project company alone. Don't expect that the sponsor of the project be on the hook or be liable for the loan repayment obligations as well. And these are very complex projects that are, I listed out the types of, like some of the parties that are usually involved in these types of projects. From sponsors, which are usually the company that wants to develop the project, say Shell wants to, or say any company, a multinational company wants to develop a power plant in a country where they may or may not have operations. They can do it with their own funds. They can go to the capital markets and raise general budget support for their capital expenditure program, or they can do project financing that is going to be off their balance sheet, that is not going to affect their financials, and that is going to be paid out of the revenues of the project. And at the IDB, because we have these two types of projects, operations, public sector and private sector, there are very two different approaches, two different risk profiles for the bank as a lender, and two very different approaches to documentation and insuring against these risks and addressing these risks contractually. If you think about public sector projects, if you think about, for example, the Bolivia-Brazil natural gas pipeline, which was one of Latin America's, if not the largest, like one of the largest infrastructure projects. It had IDB financing, but it had IDB financing out of its sovereign guaranteed operation or public sector window. Financing was provided to a subsidiary of Petrobras, the Brazilian state-controlled oil and gas company. And guarantee was provided by the Federative Republic of Brazil, the federal government. Because this guarantee was provided, we, as lenders, did not have to reflect in the agreement, to cover in our loan agreement and our financing documents, a very exhaustive list of risks, because all these risks were really insured against with a guarantee. If anything goes wrong, if the project is not completed, if the project is not properly operated, if there's a business interruption, all the bank would be concerned about was, from a development standpoint, there's a concern that the project goes through. But from a creditor, strictly legal risk standpoint, is that we get repaid. And we would get repaid relying on this sovereign guarantee. With the private sector, for example, without a sovereign guarantee, you have a whole host of risks. The risk of construction may never start. You may not get the permits from the government that you need, or you may not get environmental clearance. You may not, construction may start and not finish. There may be cost overruns. There may not be revenue, after all. So you need to make sure that all these risks and aspects are dealt with and are covered in the contract And usually the risks are identified and allocated to the parties that are best able to handle them. So revenue, construction, you would get a construction bond to cover your construction risk. Your business interruption risk, once the project is completed, the construction is completed and the project is being operated, you get insurance. You would require as a lender that the project be insured at certain very specifically established levels. If you think of, for certain cases, you may want to get credit enhancements. You may not get additional support guarantees. You may want to get, you may want to have a contract, depending on the magnitude of the project, of course, but you may be able to negotiate a contract with the host government. You may be able to secure some tax holiday that will benefit your project. If it's a project that has a magnitude and a developmental impact that is so great for the country, you might be able to do that. So in project financing, private sector or commercial basis, project financing, there's a very large number of, a very long list of risks that need to be addressed in the project documents. And that's the importance of documentation. Project financing is basically a financing technique that for lawyers, it's great. We have a very, very important role in these types of financings because the entire financing technique is based on all these contractual rights, obligations, requirements, and protections. So you need to make sure that all these risks are addressed in the contracts, and all the contracts work together. The provisions, the force majeure provisions, for example, match in all the contracts, in the financing document and the supply, the agreement that the project company is going to have with the suppliers, the agreement that the project company is going to have with the off-taker, the buyer, final purchaser of its product. So it's very complex and involves a large number of documents, and very detailed work is involved. So that was just to give you an overview of project financing. So in the IDB's private sector, or non-sovereign guaranteed operations division of the legal department, lawyers do work on these projects. They work with outside counsel, just to give an idea of how our day-to-day work is. We work with outside counsel, international counsel, for the international aspects and U.S. aspects of all the contracts and the transaction and the entire project. And we work with local counsel to make sure that all the risks that are not covered by sovereign guaranteed, for example, enforceability risk, because this is a contract that may need to be, these contracts may need to be enforced locally. Operation and maintenance agreements, construction contracts, insurance policies. So we need to make sure that all these agreements are enforceable under local law, that despite the differences in the legal systems won't compromise the viability of the project or the protection of any party's rights. So turning to opportunities, just to wrap up, 1 minute. Turning to opportunities in Latin America, I think I'm going to focus on what the trends are in multilateral financing. What we've been seeing at the IDB in the past few years has been a significant increase in the number of local currency loans, local currency financings. And this, again, with the flexibility and the expansion of types of products that the bank is offering, we've been seeing more local currency financings. It's not available to all countries, but it is available to a number of countries. And I can talk about the local currency, the currency exchange variation risk, if you want me to talk about it and who bears it. But in general, these contracts, these local currency products are available to borrowers for which, and transactions for which the bank would be able to secure hedging, essentially, from foreign exchange risk. And another trend, a significant trend in our non-sovereign guaranteed operations side is the increase in the number of private sector projects and funds, bank funds and resources dedicated to finance private sector projects. And especially, and this is a relatively new thing for the IDB, maybe a new thing for other multilateral lenders as well, the granting of loans without a sovereign guarantee to municipalities, basically municipal finance, municipalities, provinces, states, as well as public entities and parastatals. For example, autarquias or public agencies and public mixed capital, public-private companies, as for example, I don't want to cite any examples because I'm not familiar with any specific parastatal borrower from the private sector, but because we all talked about Petrobras before, Petrobras is a parastatal. It's a public-private company, really. It has stock traded in the capital markets in New York and internationally, but it's controlled by the state. The state has a majority, a controlling interest in it. So these were really my thoughts, and I hope I was able to give you a flavor of how multilateral lenders work, what types of operations we are active in, we engage in, and just to illustrate what multilateral financing is for you guys. If you have any questions, specific questions on specific legal risks, I'd be happy to answer afterwards. Thank you.
So I'm the last speaker. This reminds me of a conference I attended to a couple of months ago in Cartagena, where I was again the last speaker, and everyone was very anxious to leave. So Carlos asked me to give you guys a few closing remarks, and these are the thoughts when I talk to my colleagues and business partners on what we see going on in the region. The first feature, the first biggest trend is we don't see Latin America being affected so much by crises in other regions of the world. It used to be before that if there was a Russian crisis, the whole Latin American market would be impacted, or even the current crisis in the financial markets in Latin America has not hit so hard the Latin American financing markets. So that's one of the biggest trends. Second big trend in the region is there's a significant amount of intra-region activity that we didn't see that much of 5 or 10 years ago. There are significant investments from Colombian companies in Brazil, from Brazilian companies in Argentina, from Mexican companies within the region too, which makes the whole investment environment very, very different. The third feature that's very interesting is there are some companies that had such a sophistication and size that in the region that are starting to export transactions. It used to be that the region was mainly looking for investments from foreign investors. There are some companies that have gone out of their countries and outside the region to acquire other companies or make investments. If you think about Cemex, the Mexican cement company, they made a significant acquisition outside Mexico, outside Latin America. The same with CVRD in Brazil, Tenaris in Argentina. Those are all good examples of this trend of significant, very sophisticated companies from Latin America investing outside the region. Another trend that we see more and more is within the region itself, there are more and more transactions of regional reach, specifically within Central America. There's a significant number of transactions and investments that cover more than one country or more than one company at the same time. This is a feature that we see more and more coming up. Another feature that is quite interesting is the development of local exchanges. It used to be that many of the companies were very interested or looked as a bit big privilege being listed in a US or UK exchange. Now we have some capital markets, domestic capital markets that are equally strong and very effective for local companies. The Mexican exchange is an example. Brazil is, of course, a very interesting example. The Peruvian capital markets also is a very, very interesting example of local funding for companies. The other feature that we see, I think is coming up more and more frequently, is how U.S. and other investors from other regions have learned to deal with the region better. It used to be, as it was mentioned before, that we were trying to export the U.S. legal models into the region. And what has happened in the last few years is investors from the U.S. and elsewhere have learned to live with the realities and limitations of our legal systems and our cultures and the way business is conducted. And I always bring up this example in a recent transaction in Brazil where a U.S. public company was selling a forest. And the issue is that for almost 200 years, title to the land had not been transferred to the actual owner. This was of big concern to the buyer, who said, how can you sell this forest to me which you don't own of record? And the company said, the seller said, well, this is not really a problem. This is the way business is conducted in Brazil. Normally, real estate registries can take many, many years to register transactions, and sometimes they just don't register them at all. They keep the paperwork, and you can go back and reconstruct what happened if you're patient enough. But here you're missing 200 years of history. And although the investor was thinking that people were trying to pull a fast one, talking to people in Brazil, they realized that almost everyone in that business was probably operating under similar circumstances. The last point I want to make about a big trends we see in the region is in the last 10 years, the business people and lawyers and investment bankers in the region became extremely sophisticated. Many of these professionals operate in a way that's similar to professionals in the business in the US, in Europe, or elsewhere. Many of the bankers you come across have been trained in the US. Many of the lawyers that you deal with on a daily basis in the region have been trained or have been trained partially in the US and partially in their countries. And the same applies with the actual managers of business. You have many managers of business that have actually had some experience outside the country or outside the company you first meet them at. It used to be 10, 15 years ago, people would keep their jobs for their entire career with the same company. And now people move around and operate in a very similar fashion as in the US. And that gives them a much broader experience, which used to be something that people in Latin America didn't think of very highly, to change jobs very frequently. And the last point I would make is a trend that is quite interesting in the more recent privatizations that have been taking place over the last 2-3 years. Used to be that all participants in privatizations used to be foreign investors interested in acquiring the asset. What we're seeing more and more is a lot of local participation in privatizations, not only from the same country where the asset is being sold, but also intra-region transactions. And you have Colombian companies buying privatized companies in Brazil, or Colombian companies buying Colombian privatized companies. And my final remark would be about the Venezuelan situation. I think that people have been very concerned about what's going on there. And it seems that two things had happened. Number one, the crisis in Venezuela has not affected the markets elsewhere, and if the markets in Latin America are softer than last year, is not related to what's going on in Venezuela. And secondly, as people are debating what's going on in Venezuela, one of the state-owned companies in Venezuela has just announced a very significant debt transaction in the capital markets. What's interesting enough is that there's no investment banker which would take today a client in the US to the capital markets to raise funds, although the bankers here felt confident enough that they could take this company to the capital markets and raise a significant amount of money, despite the situation in Venezuela, which probably shows that to some extent the region has matured significantly over the 5-10 years, and people are doing many transactions and many things that I strongly believe were unheard of or unthought of a few years ago. So those are my remarks. We are free for questions.
Thank you very much, Alejandro. And Teresa, questions, please?
Yeah, I have a question about the whether or not lending to the private sector affects the development mandate at all. Is there an extent to which there are other sorts of covenants that need to be built into these loans to make sure that the money isn't sort of...
Yes, absolutely. Well, first, lending to the private sector is considered to be very much a part of and consistent with the development mandate. It's development through private sector financing and private sector development. Private sector development has a very strong, recognizedly, a very strong impact in development, overall development of a country. And so on the first answer is that it is part of the development mandate and consistent with it. And specifically with respect to the contracts, the contractual frameworks, the types of contracts that we use and the contractual provisions that we use for private and public sector transactions, they're very, very different. On the public sector side, we do not, for example, to illustrate my point, we do not adopt any, as governing law, the law of any specific jurisdiction. We follow bank rules, IDB rules, and matters are subject to arbitration, for example. And the terms of all public sector contracts are made public, so you can access project documentation at the IDB's website. On the private sector side, or the non-sovereign guaranteed side, on the other hand, operations are more on a commercial basis, and because they don't have this guarantee, but with the full faith and credit of the sovereign government, we need to make sure that the contracts really address all the risks, and therefore they do contain a lot more provisions, covenants, affirmative, negative, and financial covenants, and they have very different terms from the terms of public sector side contracts, and they're usually governed by New York law, as are, for example, the international finance corporations contracts, their loan agreements.
Why New York and not Washington?
Pardon?
Why New York and not Washington?
Oh, we're based in Washington.
Yeah.
Why New York law?
Yeah.
Oh, because, and why not Washington, as we're based in Washington? Yeah, because we find that New York law is more developed and more certain with respect to all the types of rights and obligations that will be enforced. So Washington, D.C. law is does not have such a sophisticated, complete, and certain body of law with respect to all these types of commercial transactions and financings as does New York. That's why.
Another question for Teresa. Is the IDB currently issuing political risk insurance for Venezuela, Bolivia, and Ecuador? Do you know? And if so, has the price gone up?
know that there are, I work with, and I'm sorry, I forgot to mention that when I first started. I work with the countries of the Southern Cone. So I work with Argentina, Brazil, Chile, Paraguay, and Uruguay. So I'm generally aware that the Venezuela portfolio has not been very active, but I don't know whether there are specific guarantees being provided. I really don't know, but I'm confident that this information would be, if for public sector projects, would be available on the bank's websites. For private sector, perhaps the existence of the transaction, not the guarantee, not necessarily its terms and conditions.
With regard to trends, I was wondering if there were any if you could speak to whether or not there are any trends involving China. I mean, many of the people spoke today of capital coming in from the U.S. and Europe, but China seems to be taking a bigger role in terms of interacting with the greater world, and I was wondering.
Well, from the point of the IDB, China is not a member country, so it's not active within the IDB universe. But we do read about, and we are generally aware of China's expansion, China's financing and investment expansion into the developing world, Africa and Latin America. But I don't have any information that is more specific to than what's out in the papers.
Alejandro, I would like to ask you to go deeper on the concept that Latin America is not being very much affected by the financial crisis.
Look, if you see what's going on in the U.S., the crisis is very severe these days. Access to credit is very limited in all forms, in all shapes and forms. Commercial lending is very restricted, and capital markets is almost non-existent. And still, in Latin America, we see a significant amount of activity. Perhaps capital markets is slower, or it's a huge pipeline building up, but still, there's a significant amount of bank lending and a significant amount of M&A activity. So, in general terms, I think that the activity, the level of activity in Latin America has not deteriorated as much as in the U.S. Lately.
And is that with local investors, or are there also U.S. and European?
There are a number of overseas investors looking at opportunities there. There are a number of European investors with very strong currencies that find very attractive opportunities. And there is some interest of U.S. investors also. They're looking at opportunities, the fairly large opportunities that are becoming available in the U.S. and outside the U.S.
Is that trend sustainable in a medium term with the U.S. crisis if it goes deeper?
I think for companies that have a good credit and a fairly good business position right now, they may start looking seriously at diversifying their risk geographically based on what's going on today in the U.S. and consider investing overseas as a natural hedge to economic cycles.
Maybe add a comment. I think there's a repricing going on now. If you look at, say, the Brazilian capital markets, which have been very active on the debt side, where the Brazilians want to borrow and where the international investors will lend is not matching.
But Brazil is a totally atypical situation. The Brazilian capital markets, we're discussing this before this conversation, has lived of secondary equity offerings for almost 5 years, where no money is going into the companies, just families cashing out, and there has been no debt capital markets transactions. So the Brazilian is a very weird animal. But I agree, where lenders want to lend in Brazil, there's a huge mismatch with the expectations of the Brazilian market.
Yeah, and I think to the extent that Latin America relies on international capital markets, that there will have to be a convergence. There'll have to be a repricing at some point.
Yeah.
But on the other hand, if the domestic capital markets are well developed, they may go for 6 or 12 months without needing a partner.
Yeah, but that's what happened with all this so-called IPOs in Brazil, because there's a huge local demand for this instruments.
Noted.
I was just going to comment, I think, on similar lines. I think, for example, in LBOs, I think in LBOs or in acquisition financing, which we see more in Latin America over the last few years, I think they're certainly becoming much more expensive and harder to do in Mexico, somewhat less so in Brazil. But I was also going to say, I think that it's also worth distinguishing in terms of the crisis between what's happening right now, which is, I think, fundamentally a credit crunch, and the other aspect of it, which is the risk of a recession. And I think that, if the recession happens or is happening, as many people believe, I think that's likely to have a much broader impact, particularly in some countries like Mexico.
I have a question for Teresa. From your presentation, I understand that IFC, when grants a loan to a borrower, split in a tranche A and a tranche B, and the tranche B participates to other financial entities or to other investors. The question is the relationship between the IFC and the participant in the loan affect the loan between the borrower and IFC? In other words, for example, the loan agreement provides that the IFC will not make the loan if he previously obtained the funds arising from the participation of the loan, something like that, or the relationship between the IFC and the participant has nothing to do with the loan to the borrower?
In general, these loans are done in two, we call them like the AB loans, like the A loans stay with the IDB, or in the case of the IFC with the IFC, and the B loans are participated. But they can be in one tranche or in several tranches, but we call these tranches A and B loans, separate loans. And the relationship between the multilateral, in our case the IDB, and the participants is separate from the relationship between the IDB as the lender of record and the borrower. Like bilateral relationship, and then you have a separate set of relationships between the lender of record and these participants. But it does affect in that, for example, you may have in these participation agreements terms that will be somehow reflected in the loan agreements. For example, to the extent anything needs to be voted and decided by a majority affirmative vote, or certain rights, like essentially the rights of the participants will be somehow reflected in the loan documents, the loan agreement, but they won't be a party to it. There will be no relationship, no privity of contract between participants and borrower.
Then you're based in Washington and you have all these member states and you just describe the mandate, but how the governance works, who is on the board, just give us a little bit of that background, which we maybe can find everything on the internet.
Sure.
Excuse me, I didn't hear the question.
The question was...
Can you repeat it?
Sorry, I'm about to push the button. She will.
I think I can summarize. The question was with respect to the governance of the bank. This information is available online, but I can give you just an overview of bank governance. We have member countries that are borrowing member countries and non-borrowing member countries that are essentially virtually all Latin American countries, and the United States, Canada, several European countries, such as Austria, Germany, France, Spain, Israel is a member country, Korea, Japan, and well, these are the non-borrowing member countries. The Latin American countries are the borrowing members. And there's the highest body in the governance structure is the Assembly of Governors, the Board of Governors, which would, I guess, correspond to a board of directors, but not really. It's a board of governors, each appointed by their constituency, by their country, by their member country. And this board of governors meets every year and takes the decisions, like overall policy decisions and direction of where the bank is going. They're actually meeting right now in Miami. The annual meeting of the governors is going on in Miami today through early next week. And you have a board of executive directors that are not as many in number as are the members. So you have directors that represent constituency of multiple countries. And the board of director meets very often, actually once a week, and deliberates on, votes on, and approves every loan transaction, pretty much every loan transaction. There are certain thresholds for pre-approved transactions or for, like in the case of technical operations, by amount involved. But the board of directors board of executive directors is very involved, hands-on on the operations of the bank. And you have the bank staff that is, I think in its majority, based in Washington, but now more and more based overseas in our representative offices and our representations, which are, I think we have one representation in Europe, or maybe more, but one as far as I know, and one in each of our borrowing countries. And the staff based in the countries are the people who are, basically working with the governments during the life of the loan, after the preparation, after the documents have been executed. They're really seeing the projects through. And we have policies that are adopted by the Board of Executive Directors that govern what types of operations we can engage in, the parameters of these operations, of anything from types of financial products to human resources issues is dictated by these board-approved policies.
If I can ask, which country has the strongest representation maybe on these boards? Do you have any statistics on that?
I was going to put a pie chart in my presentation. I thought, no, nobody's going to ask about it, but I should have. Okay. Actually, I know I don't have the statistics. I know they're online. We can look it up. But I know that the IDB is one of the few, or at least was first of the multilaterals that did not have non-borrowing countries be the majority of the voting power. So it's a balanced, there is a balance in the voting power, and there is, in practice, in reality, you see that there's not one single country that has a voice that overrides anyone's votes.
So you mentioned that there's a distinction in the private sector lending. There is no, there aren't covenants in there for commitment to environmental or social aspects?
There are.
There are, in the private sector?
Yes.
Oh, okay.
Bank-wide. Oh, I'm sorry, I thought your question before was broad and not specific with respect to environmental provisions. We have environmental provisions both in our public sector loans and our private sector loans. Even the loans that are granted on a commercial basis on the private sector, we have a number of environmental provisions. And that's why I mentioned before that some borrowers may see it as something that might be, it's a differential. Some other lenders, I don't know, some non-bank lenders or banks that are not equator, some banks may not have some other financiers may not have such stringent and strict environmental requirements, but this is very much consistent with our development mandate, and it's in there both for public and private contracts, or public and private sector operations.
There's also usually a requirement that the money be spent on capital expenditures. So it can't be for refinancing or working capital. So that's the kind of there has to be a project, a designated project. Makes it hard for some borrowers.
We have the policy-based loans in the public sector, which are not specifically for projects, but are very much for a lato sensu type of activity or project, is to reform policies. But again, it's very specific, for a very specific activity, field of activity.
You mentioned operations, financing operations in Latin America that are strictly local, and I wanted to know if there is a role there for the U.S. Council, and what is it?
I believe that normally you'll see less and less of a role, and that should be the natural development. One thing is to notice is many of the firms in the region have alliances, and they work very well together, so they have regional reach. And in many of these transactions, I think U.S. lawyers become involved from the beginning because that has been the tradition, but in most of these cases there's really a very limited need, except that once U.S.-style law firms get involved, they normally take over the process. But you could envisage a process being run domestically without need of involving any U.S. firm.
That's it.
I think it's really also a question of a transfer of a lot of know-how.
So louder, please.
I think it's a question of transferring a lot of know-how to local law firms. I've worked, and I'm sure many lawyers who work on cross-border transactions have worked on a number of transactions that have no New York nexus. But I think people come to U.S. law firms because they know how to do the deal. But I think as local law firms get that know-how, as they kind of understand them and do it up with them, then I think the U.S. lawyer becomes a little superfluous. One thing that I think the U.S. lawyer does add is, I think, a regional knowledge. I think when you do deals in 10 different countries, I think you understand that different ways of solving problems, which a lawyer that does business in only one country is not going to get. On the other hand, as you were mentioning, because of so much of the cross-border transactions that are going on that are just within the region, I think a lot of the local lawyers are getting that expertise as well.
And there's so many of these young lawyers throughout the region that have been trained, spent a couple of years in New York or elsewhere in the States and have been trained there, and there's also so much information available on the internet, forms of contracts. You can go to the SEC website. There are so many programs to search for different type of documents, precedents, things that were not available 10 years ago that now are readily available. If talking about Brazil again, if you see what's going on there, Brazilian companies and law firms have said, look, when we do an equity offering, we don't want a U.S. law firm running the show for us. We're going to do it, and the U.S. law firm is going to give us specific input on disclosure issues or precedents, but we are going to be in charge of documentation. And once we're ready, we're going to translate this into English, and that's going to be the offering document for the U.S. too. And that's a fairly generalized pattern in Brazil. And I think the pattern is going to be more and more general in the region.
Another question regarding your comment is, you had your careers in Brazil, in Argentina, you were successful there, and you moved to the U.S. to continue your practice. I wanted to hear some of that story and how that developed.
It wasn't a thought through move beforehand, really. I really came here to Washington to get my LLM, and I thought it was coming for 9 months. But getting here and having a chance to take all those classes in international finance that I wanted to take, it really sparked my interest in experiencing international finance from the International Council standpoint. as Alejandro mentioned, like the legal market is evolving, but I came here 10 years ago. 10 years ago and before that, you had a very clear distinction between international work, like cross-border work that you do from a specific country, and cross-border work that you do from the US. And I thought, and now this has changed, it really has. But back then, I thought it'd be very interesting to have experience working in international finance in the US, international business transactions from the lender or the US standpoint. So I started working at a Washington law firm, Hogan & Hartson, initially with my practical training visa, and got offered an associate position, and I decided to stay because I really enjoyed doing the work very much. And then at that point, I decided that I did want to develop my career here. It's an adjustment because for those who have worked for a number of years or for a small period, but for those who have developed a career back in their countries, it does take starting over, because it does take learning about an entire new legal system, a very different work culture and work style, but it can be very interesting and rewarding too, if this is what interests you. So in my case, it wasn't thought through before, but then it was a deliberate decision to do the transition, and I've been working here for about 8 years now.
My story is a bit different. I met a couple of partners from my current firm working on a deal in Argentina across the table from them. We were representing a seller, and my current firm was representing a buyer. And it was a very difficult transaction, and I thought after the transaction finished that these people would never talk to me again. And instead, after a month or so, they called me to ask me whether I wanted to join the firm, and it took me a little while to make up my mind. And what was appealing for me is that my firm does not have a group of people that work in a specific area of the world, but you have to be able to work wherever you work and do domestic U.S. transactions and cross-border deals. So that was very appealing to me, and after a while I make up my mind and restart my career here.
So, given the actual situation in the U.S. market, how do you, all that practice with operations in Latin America, see the possibilities for Latin American lawyers in getting inserted in the U.S. market?
I think, in my experience, to the extent that U.S. firms continue to play in a very important role in transactions in Latin America, I think that lawyers that have a U.S. training and a training from a civil law jurisdiction can make a significant contribution, a really significant contribution. I also think that more and more language skills are becoming critical, but by this I mean not being able to say hello and order a meal from room service, but being able to sit down at a table and negotiate in Spanish or Portuguese a sophisticated transaction, and being able at the same time to draft your documents in English. There are very many significant transactions where there's not a single word said in English at all during the negotiations, and the only English that's being used is for the documents, but there's never ever any discussion in a language other than Portuguese or Spanish. So I think that it's a bit of a function of how much business the law firms have, and that tends to be cyclical. But I think for law firms in New York and the U.S. generally, it will be more and more important to have people that can that understand the issues firsthand, the legal issues, or the civil law issues with perfection, security, interest, transfer restrictions of stock, all the things that we face every day, and that can have an open negotiation in a foreign language. That's always a very, very positive thing to have for any law firm.
I entirely agree. I would just add that there may be also opportunities outside of private practice that people should also consider. There might be opportunities with multilaterals, might be opportunities with nonprofits, there might be opportunities with the private sector. And in the U.S., there are many types of legal work that can be done in the U.S. that can be a significant and very valid experience for foreign attorneys before they go back home or to transition into a new career here. So it's like there are also other opportunities there for you guys to think about.
Any final words from someone? So, thank you so much for being here until this hour. It's good that we have some very nice Latin American food and some wine and refreshments out there waiting for us. I hope you enjoyed this afternoon as I did, and I hope that you will join us for the second annual symposium sometime next year that we will certainly let you know. I am really proud of the panelists we had here today, of the discussions in which we enrolled, and I certainly encourage you to make of this the first day in long-standing relationships. People get in touch, meet each other now while having a glass of wine. Thank you again, and good luck.